دارای وکیل‌های حقوقی هستند که آقای بری در حدود 35 سال سابقه وکالت دارند که 20 سال از این سابقه وکالت خود را در زمینه ادعای حقوقی برای مردم در زمینه‌های قصورات پزشکی و حوادثی که روزمره ممکن هست شما عزیزان با آن دست و پنجه نرم کنید و یک اتفاقی برای شما انجام شود و بخواهید که او را از نظر پزشکی و یا از نظر قانونی غرامت طلب کنید در قبالش. این وکیلان امشب برای ما اطلاعات مفید را ارائه خواهند کرد و در ادامه آن خانم دکتر شمیم اکبر را خواهیم داشت که این اطلاعات را به زبان پشتو برای ما ترجمه می کنند و در خدمت شما عزیزان قرار می دهند. لطفاً با ما باشید تا پایان برنامه و از این برنامه بسیار آموزنده غافل نشید. تشکر از توجه شما عزیزان. مهمان نخست برنامه امشب آقای بری هستند که از ایشان تقاضا می‌کنم تا سخنان خود را ایراد بفرمایند و تشکر پیش از خانم شمیم که به دنبال ایشان ترجمه پشتو را به همراه خواهند داشت. سپاس.
All right. Okay, so I'm going to be talking a little bit about public liability because quite often people in our community are aware of rights associated with workers' compensation matters and also with motor vehicle accidents because there are very well-managed and well-understood schemes that provide for compensation for people who are injured in those circumstances. But public liability and indeed medical negligence, they're quite different because we don't have those sorts of schemes. So we thought it was important if we perhaps talked a little bit about the areas that we're in so that we can perhaps inform you and educate you and answer any questions you might have about what it is we do so that you can share that with the community. So if I can have the next slide, please. Perhaps the next one as well. So this is what is public liability, and what I've done there is provided a little bit of a wagon wheel to show the various sorts of accidents that I see and my team see at the Dandenong office concerning incidents that occur to people where they're injured in circumstances where their injuries occurred through other people's negligence or carelessness. So obviously at the top there's things like slips or falls. They're the sorts of things that we see quite frequently, but there are also accidents that occur to children while they're at school or even parents when they're picking up their children. In playgrounds, physical assaults, dog attacks, aircraft or aviation accidents as we call them, food poisoning, although they're sort of pretty rare these days fortunately, but also accidents that might occur in recreational activities, that's sporting events, those sorts of things, accidents that happen when you're visiting other people in their home, and also other sorts of assaults, both physical and sexual. So they're sort of a bit of a snapshot of the sorts of incidents that we see which cause people injury. So it's very broad, and that's not a list that is all the sorts of things that we do, but they're kind of the most common things that we do see. So if I could have the next slide, please. So the thing about public liability claims are that they're not handled by a lot of lawyers. So we've found over the years that you'll always get a much better result if you get someone who is very experienced in handling specialised sort of legal work, be it medical negligence or public liability. So our advice is always make sure that if you are going to see a lawyer, you see a lawyer who is experienced with public liability because it's often appears to be a fairly simple area, but it's an incredibly complex area, and a lot of lawyers that I know who don't work in this area don't have a clue about the sort of work that I do or what needs to be done to get the best results. So it's very important that if you are injured that you see someone who is experienced and knows what they're doing in this area. The other thing is that it's most important that in these cases we're always hoping or making sure that there is someone on the other side who has caused the injury or caused the injury and accident to make sure that they're insured. And what's important is that all businesses generally are insured. Most people who own homes are insured as well, and those insurance policies cover them in case a visitor to their home is injured through carelessness or negligence. The other thing about public liability claims is that, and this is what makes them quite different from workers' compensation or motor vehicle claims, is that you don't get any compensation until the very end of the claim. So if you're injured, you can't apply to the insurer to get your medical expenses paid. You can't apply to the insurer to get your income covered whilst you can't work. In public liability and indeed medical negligence, you simply have to wait till the end of the case. So you are very much waiting until you're successful with the case. And that's again why you need someone who knows what they're doing and can move the case along swiftly. But they don't move all that quickly, unfortunately. They can sometimes take a year or two, sometimes longer, depending upon how complex they are. And you'll see down at the end of that slide, I've noted that public liability is really controlled or governed by two areas of law. One is the common law, and one is through legislation or law that's made by the Parliament for Victorians and indeed Australians. Next slide, please. So I mentioned common law, and common law is an expression that we use commonly or frequently as lawyers, but really all it means is law that's been developed by judges. So when courts sit and hear a case, or a judge hears a case, they will make a decision and they will provide their explanation or the reason why they make that decision, and that becomes part of our common law. So that's quite a distinct way in which we have a lot of our law. A lot of our law has been developed over the last 200 years, 300 years. A lot of it comes from England, in fact. But we're also governed by legislative law, or statute law as we call it. And we have a piece of legislation called the Wrongs Act, and that really sort of, in some respects, does the same thing as common law, but it doesn't go into as much detail as the common law goes into, but it provides some framework or mechanism as to how we operate within the law, what procedures we have to follow, and what limitations or restrictions that there are that might be imposed. So it's important that we've got the common law, but we've also got the Act, which sort of really modifies in some way the common law. And I've just mentioned again there that it is important that we find that there's insurance on the other side, because someone's got to pay the compensation to the injured person, and hopefully that's an insurance company. Next slide, please. All right, moving on to the next one. So we're going to have a little bit of a closer look at the common law. So as it's noted there, it's developed from decisions that are made by judges or the courts. And what's critical is that we have to establish that another party has been careless or negligent or responsible for what's happened, which has caused the injury to the person. And when we think about what negligence is, or what careless conduct is, what we're really looking to see is whether or not the person who we think was negligent had an obligation or a responsibility to look after or safeguard the other person. So for example, if a person is coming onto my property, perhaps they've been invited in, or perhaps they've come in to do some work at my place, then I have what we call a duty of care. And that's really an obligation or responsibility to make sure that there are no hazards or dangers around my house that might cause that person to be injured. As the occupier or owner of the house, I'm expected to know if there are dangers, and I should do something about that. And the law says that's my duty, that's my obligation or responsibility. We then have to establish that the person who had the duty of care breached that duty. In other words, they didn't do what the law says they should have done. So back to my example, if someone comes onto my property and I've got a duty to make sure that things are safe, then if I've dug a hole in my front yard, then my duty would be to cover that hole up if I knew people were coming on, or even if I thought people might come on, or put a barricade around it, or warn people that it was there. So the duty is for me to do something, and if I don't do that, then I'm said to have breached the duty. So if I'm in a supermarket and someone's spilt some oil on the ground, then the duty of the supermarket is to make sure that's cleaned up quickly. And if they don't do that, then they're said to have breached the duty. And the last thing we have to prove, the last element, if you like, of negligence, is that we must then show that that breach of that duty, the failure by that person to look after the interests of the person who came onto their property, has caused them to suffer loss and damage. And that means caused them to suffer loss because of the injuries that they've sustained. So in short, for us to establish a common law claim, we have to prove that a person has suffered loss and damage because there was a breach of the duty that applied. Okay, next slide, please. If we can establish that a person has been negligent and we've been injured, then we as the injured person can claim various things. The first thing we want to claim is that what we call pain and suffering, or loss, and that includes loss of enjoyment of life. So the injury might cause us quite a bit of pain, it might cause some suffering, but that might be an ongoing issue that we have. It might be an injury, a back injury, for example, which causes pain and suffering forever, if you like. But also there's loss of enjoyment or loss of amenity, and that means we're restricted in what we can do. We can't enjoy our kids, enjoy our grandkids, enjoy the social activities that we used to engage in, enjoy dancing or hiking or push biking or even walking. So that's where we get compensated for that pain and suffering, and that's very personal to us. But we also want to claim for the expenses we've incurred for things like the doctor, the hospital, the ambulance to get somewhere, the medication that we might need for our pain relief, all those sorts of things, and indeed even the care that we might need from our family and loved ones who will look after us while we're injured and while we're recovering. So all those we're going to claim as part of our compensation. And the last thing we might want to claim if we're unable to work because of our injury is what we call loss of earnings and loss of earning capacity. And that really means if I'm injured and I can't work, then I want to claim what I've lost. But if I can go back to work and only work part-time now because of my injury, then I want to claim the difference between what I could have earned before I was injured and now what I can earn with the injury. So all those things, those three things, are what we want to claim if we can prove that someone was the cause of our injury. Next slide, please, Wissy. So, in terms of the common law, as I mentioned before, was just modified a little bit by the Wrongs Act or by the legislation that the government put in. And what they said was, if you can prove that someone was negligent and caused you to be injured, you can recover your medical and related expenses. That's okay, no problems. Similarly, if you can prove that another party was negligent, you can claim your loss of earnings. However, the government decided to restrict access or the ability for people to claim for pain and suffering. So now you must have an injury which is regarded as significant injury if you want to claim that pain and suffering and the loss of enjoyment of life. And that's a very important component of most claims, particularly in public liability. So if we want to claim that for our client needs to be able to demonstrate that their injury is significant, and a significant injury is categorised or classified according to following a medical examination, so that if they've had an injury to their spine, the injury must be said that it must be 5% or more of the whole person. And if it's just a normal physical injury like a broken bone or a laceration or a loss of sight, for example, then it must be more than 5% or 6%. And that's measured according to a medical book that special doctors have to use when they're assessing. So it's not a question that I can say, well, that's definitely over 5 or that's definitely under 5, because I'm a lawyer, not a doctor, so I'll need to ask a doctor that question. And we do that once the injury is sort of settled down a bit. To be frank, for people like Lee and myself, we've got a pretty good idea of what is or isn't over 5%, but ultimately it's not our call, it's the doctor's call. And for psychiatric injuries, for people who are psychiatrically impacted as a result of someone's negligence, then their injury must be 10% or more in order to qualify for the pain and suffering. And you can see the last line there says that compensation is currently capped at about $644,000. That means that for the pain and suffering component of any compensation claim, the maximum that a court can award is $644,000. And that's generally reserved for the most serious injury, for example, an injury where a person suffers a spinal injury to their neck so that they can't move their arms or legs, they're confined to a wheelchair and need help all the time, or they may have brain damage and require constant care, they would get $644,000. But if you had a broken arm or a broken shoulder, then you wouldn't get anything like $644,000, but you'd still get a substantial amount of compensation if you could prove that negligence. So that's how the compensation is worked out. Next slide, please. So this is just a reference to the fact that if you do have an injury, the law is quite strict in that it requires you to do something about that within 3 years. And it's usually within 3 years of when the injury occurs. So if you know someone who gets injured or you hear of someone who gets injured, it's important that they know that they've got advice that they must do something within 3 years. Because if they wait till after 3 years, they may not be permitted to continue because they've left it too late. There are circumstances where a court can allow them to bring a claim after 3 years, but it's a very risky proposition. So we encourage people to get legal advice early and do something before the 3 years runs out. If an accident happens to someone who is under the age of 18, we call that person a minor, M-I-N-O-R, minor. They're a child or a person who's got a disability, intellectual disability. Then they have 6 years to bring their claim. So they're given a little bit longer to do something about it. But it is important that they get advice early and do something about it quickly. And those limitation periods apply not just to public liability, but also to Lee's area of medical negligence. So that's a very important thing for people to know, that there are these limitations that apply. And as the last point says, it's only in circumstances where a person suffered physical or sexual abuse while they were under the age of 18 that no time limits apply. So that's a very rare thing. So 3 years generally. The only little wrinkle there is that if you have an accident on a plane or as a result of an aviation accident, then the limitation period is 2 years. So that's a bit different, but 3 years for general public liability claims and medical negligence claims. Next slide, please. So this is just a quick list of the types of injuries. I won't go through those, but what you can see is there's all sorts of injuries, from fracture injuries to eye injuries, there's hearing injuries, head injuries, amputation of limbs, anaphylaxis, bad reaction to things like peanut butter or bee stings or those sorts of things, animal attacks, etc. So that's the physical injuries that we see most commonly. Next slide, please. Then we come to psychiatric injuries, and the sorts of psychiatric injuries we see most commonly are things where, say, people are bullied. People are often bullied at work, and that's where workers' compensation comes in. But if kids are bullied at school, for example, that can sometimes establish a claim if they suffer permanent psychiatric damage. Similarly, if a family member or a loved one has been killed or maimed, but in this case killed mostly, through someone else's negligence, then we may be able to claim compensation because we're psychiatrically affected by the loss of that person. We might witness a traumatic event that's similarly compensatable or compensable, attacks by animals, most commonly dogs obviously, or a traumatic event such as physical abuse, assault, or sexual assault, etc. Next slide, please. So I'm just going to run through a few sorts of examples just to give you a bit of an idea. I think it's better if you get some visual ideas about public liability in our world. So first one we're going to have a quick look at is trips and falls. Next slide. So this is a slip case, and you can see from that photograph, hopefully, you can see, you might recognise a supermarket floor there, and we're in the fruit and vegetable section of the supermarket. It might be Woolies or it might be Coles, I'm not sure. But right next door to the concrete floor is a mat. Unfortunately, someone had dropped a green bean on the floor, and our poor lady was walking, didn't see the green bean. It hadn't been cleaned up as quickly as it should have been, and she stepped on that green bean, slipped over and landed very heavily on her left knee, going underneath her, and she had to have surgery which involved quite a bit of scarring around her knee. So that's a very common sort of accident that we see, people slipping on liquids or vegetable matter in places like supermarkets or shopping centres. Shopping centres, for example, where people are walking around the food court or walk out of the food court, they might be eating some hot food, they drop it on the ground and the next person who comes along a little bit later slips on that because it hasn't been cleaned up. And that's where we might look to the shopping centre owner to say, or shopping centre cleaner to say, well, you didn't do your job properly and now that person's been injured and we can make it claim. Next slide, please. This one's an unusual one, but you can see them a little bit. You'll see that photograph there shows a nature strip right next to a roadway, and there's a pole with some orange, what we call orange bunting, wrapped around the pole. That wasn't there previously, that's important to note. All that was there was a hole. Someone had dug a hole, but someone had failed to put a cover over that hole. So when our client was walking along that area, and it was after dark, so there was no good lighting for him to see that, and they were walking across with the intention of crossing the road, stepped into the hole and suffered a really nasty injury to their low back area. And as a consequence of that, they ended up having constant or chronic back pain. They were very restricted in what they could do. In addition, they also injured their left knee because it was their left leg that went down the hole. And that caused some real problems with their knee, and that required surgery. And you can see there that indeed that case resolved for $500,000. So that sounds like a lot of money, and it is a lot of money, but it must have been a pretty bad injury for that person to be compensated. But they were compensated for their loss of earnings and also their medical expenses and also the pain of suffering that they had. So that sort of gives you an idea as to the sort of compensation you might get if you suffer really bad injuries because someone else has been negligent or careless. Next slide, please. That's just a quick example of the sort of thing we get where people say, well, I was walking along the footpath going from A to B, and the footpath was in a terrible state because the council hadn't been doing their job properly. Councils do have a responsibility to keep their roads and footpaths in good condition, and whilst cases against councils can be tricky and can be difficult, if you see someone about a footpath case and they've got expertise and experience, they'll be able to tell you pretty quickly whether you've got a potential claim. But it is always good if people are injured on a footpath because the footpath's in poor condition to get that person to take some photographs of the hazard or bad bit of footpath before they necessarily tell the council, because usually what happens is when people tell the council that the footpath's dangerous and cause them an injury, the council rush along and fix it up, and then the evidence about the poor state of the footpath or the damaged footpath is gone, and then it makes it a lot harder. So photographs of these sorts of things is very, very handy. Next slide, please. This is another simple one. You can see there, we're looking at a fast food outlet there. So lots of car parks, and car parks, they put those orange or yellow, in this case, they put those sort of yellow painted, what we call wheel stops. And that's designed to stop the car rolling forward into a wall, or in this case, a sitting area. But you can see that on the side of that photograph, there's a wheel stop in a really strange position. And unfortunately, our lady didn't see that. It was dark, and she got out of the car and didn't observe that, and she tripped on that and fell over. Now that wheel stop had been moved by kids, someone, we don't know who, but it had been in that position for some time, and it should have been rectified, that it should have been fixed, it should have been moved. It wasn't, and our lady was injured and she was compensated. Next slide, please. That's really just a picture of a play centre, no specific thing there, but just an indication that we see lots of cases involving recreational centres or play centres, trampoline centres. They're places where accidents happen, sometimes they shouldn't happen, and in this case, or that's just a photograph, but in many cases the person or the child who's injured will be injured because there's something that's gone wrong at the centre, something hasn't been done properly, a safety issue hasn't been addressed, and they haven't been warned about it. So that's the play centre. But there was a quick question in relation to one of those. I might come back to that question at the end if that's okay. Okay, next slide please. Stairs and balconies. Again, this is a common area. If you close to the next slide. I've got a picture there of a set of stairs. That's a set of stairs in a home, and you'll see they're all nice and even, but there's no handrail. And whilst they don't have to have a handrail, there was the steps were very slippery and should have had some sort of strip along the front of the step to make sure that if you didn't put your foot correctly on the step, your foot wouldn't slip off and cause you to overbalance. And unfortunately, this lady, she was renting this home, hadn't been there all that long, and she missed her footing at the top of the step because it was pretty poorly designed, and she tumbled down those stairs and has ended up with a nasty break in her neck, and she's now in a wheelchair and can't move her arms or legs. So a simple accident like that can have devastating or catastrophic consequences, and in those cases we're always looking to see whether the builder perhaps or the homeowner failed to provide a handrail or failed to provide appropriate non-slip strips. And next slide please shows a balcony, and in that particular case you can look up and see through a hole in the floor, and that's because our fellow was standing where that floor used to be, but the floor hadn't been properly made with the appropriate waterproof material, and as a consequence, over a couple of years, the floor underneath the tiles rotted, and when our client was standing on that balcony, it simply gave way and he fell to the ground below and suffered bad injuries to his back and knee. And that's a classic example of the builder was negligent and didn't do their job properly, and then a couple of years later someone gets injured, and that injured person is entitled to claim compensation for that shoddy workmanship. Next slide please. Next slide as well. This is an odd example, but I thought it was worth having. You'll see a photograph there, and as is obvious, it's a commercial premises where they sell lots of products for shops and restaurants, fridges, stoves, burners, all those sorts of things. Our fellow was having a bit of a look, and the refrigeration unit that was circled in red there, that had been sat on a bit of a step, and our fellow opened the door of the fridge to have a look and see whether it was the sort of fridge that he wanted to buy, and the whole fridge toppled down on top of him because it hadn't been properly stored or secured in the warehouse, and as a result he ended up with a pretty nasty ankle injury and also stirred up an old back injury, and he got $250,000 million for that because he ended up with a pretty nasty couple of injuries. Next slide please. It's a bit nasty. We sometimes see people go to the hairdresser and they have their hair done, and sometimes the hairdressers leave the chemicals on their hair too long and they end up getting nasty scalp burns. So again, that's a poor job by either the hairdresser or the product that was bought by the person to use didn't have enough instructions as to how to use it safely, and that ended up with a terrible result for that poor person. Next slide please. This is another product. This is a chair that was bought from one of the hardware stores, probably one of the big ones I guess, but you can see that the back of the chair is not where it's supposed to be, and that's because the stitching on that was made in a foreign country. They didn't do a very good job. It was a cheap and nasty product obviously, and when our client leant back on his chair when he was out camping, the back gave way and he fell over and suffered again a very bad neck injury. So we sued the importer of the chair, the hardware store, and got our client quite a bit of compensation for that injury. It shouldn't have happened. He was an older fellow, he'd just retired, he was out camping, he just bought this, it was quite new, hadn't really used it much before, and his retirement was ruined because the people that sold the chair didn't make sure that they were selling good, safe chairs. Next slide please. cycling accident. Next slide. This is really just a quick indication. If you have a look at that, you'll see that there's a bit of a bright green grassy section, and then the other grass is quite a dull colour. And that's because the bright green grassy section, if you go to the next slide please, you'll see that it's in fact a drain where water off the park drains into that drain and causes it to be very wet, and that causes a lot of green grass growth. But unfortunately it also disguised a ditch, and our fellow was riding his push bike along there. He just deviated off the path because there were some pedestrians walking towards him, so he went off to the side and his front wheel went down into that drain and he suffered terrible, terrible injuries. So again, carelessness on the part of the council for allowing that to happen, and they fixed it within a week. But in the meantime, our fellow's been devastatingly injured. All right, next photograph is burns cases. We often have, go to the next slide, we often see people who suffer burns from products that are dangerous or from fires that are left burning while they're asleep. All sorts of reasons how people get burnt. They might be fire burns or it might be chemical burns. But if it ends up being, resulting in significant scarring, then we generally see a right to claim for pain and suffering because of that. If enough of the skin is affected, it can really impact on a person's life because they're unable to go out in the sun, unable to regulate their body temperatures, and they can be quite nasty, and that's what happened to this person. And if we go to the next slide, which is a nasty slide, I'll just give you a forewarning. This poor lady was burnt in a house fire because someone had failed to check their gas heater. It was a rented house, and gas appliances like wall heaters and ovens and hot water services, they need to be checked every year to make sure that they're safe. And in this case, no one had bothered to check this for a number of years. And in fact, the thing had become faulty, and this poor lady went to bed, woke up with the house on fire, and she suffered terrible burns to her arms and lost a number of fingers and a lot of other body burns. It was a terrible, terrible case. But she received a great deal of money, but it's hard to think that money would compensate for that, but it certainly made her life a bit easier in other ways, and that's what compensation is about. Next slide, please. Assault cases, we'll just quickly move through this one. The next slide just shows a fellow, nice young fellow on the left, but he was assaulted by, if I remember correctly, some security guards at a place in town, and the photo on the right is how he is now because of the injuries that he sustained in the beating, the assault by the bouncers who shouldn't have been doing what they were doing. But he was compensated again because the assault shouldn't have occurred the way it did. Shouldn't have occurred anyway, to be frank, but that was a terrible outcome. Next slide, please. Dog attacks. Next slide. Sarah's managed to find a nasty dog there, and if you go to the next slide, you'll see what sort of injuries people suffer in dog attacks. Often bites to the arm when people try and protect themselves, or bite to their legs if the dog comes in to attack them. And again, if people can identify the dog owner, then usually we can get compensation for them if they are attacked by a dog and suffer nasty injuries. Next slide, please.
Thank you very much Mr. Barry و تشکر از ایشان و همتون شما میتوانید ترجمه به زبان پشتو توسط خانم دکتر شمیم اکبر را هم گوش کنید. سپاس از همراهی شما.
Public liability حفاظت کول دي. هغه حفاظت کول دي چې د بل نفر زخمی شي یا مړ شي د درېمې پارټي په نیګلیجنس یا په غفلت باندې. نو همدغه وجه ده چې کله چې پبلک لایبیلیټي کې مونږ ایستو نو پبلک لایبیلیټي خپل وکیلان لري لکه بیري چې مخکې ویل چې سلاید اینډ ګورډن کې کار کوي او هغه غواړي چې د پبلک لایبیلیټي په باره کې یا زمونږ د حفاظت په باره کې چې هغه څوک چې یعنې د یو غفلت د وجې نه د درېمې پارټي په وجې باندې یعنې زخمی شوی دی یا رواني تکلیف ورته پیدا شوی دی نو ما دلته دا ټول لیکلي، خو زه غواړم چې ډېر تاسو ته په ساده الفاظو او درته ووایم چې تاسو پرې پوه شئ. نو پبلک لایبلیټي دا ده چې هغه څوک وکیلانو ته ځي او غواړي چې کلایم وکړي، نو هغه وکیل اول د هغې زخم ګوري چې یعنې دا د دې قابل دی چې یعنې پبلک لایبلیټي کلایم مونږ د دې وکړو او که ونه کړو. که چېرته د هغې زخم 15% دایمي، نو هغه بیا ورقې ډکوي او کلایم ولګوي. او که چېرته د هغې د ملا مورې یعنې دایمي زخمي شوي وي 15%، بیا مو له ورقې ډکوي، کلایم ولګوي. او هغه څوک چې رواني تکلیف لري، نو هغه چې 10% یا د 10% نه زیات وي، نو بیا وله ورقې ډکوي او پبلک لایبلیټي وله جوړوي. نو دا د دې دپاره زمونږ د حفاظت دپاره د پبلک لایبلیټي ده، ځکه چې اوس چې مونږ ته ټول د بیرې د دې په باره کې د معلومات راکړل، نو پبلک لایبلیټي زمونږ ټولو هغه خلک چې واړه بزنسونه لري او غټ بزنسونه لري، شاپینګ سنټر دي، دغه ټولو کې پبلک لایبلیټي دا خلک د دې مستحق دي چې هغې نه باید استفاده وکړي. نو هر هغه څوک چې غواړي چې اپلای وکړي د دې دپاره، یعنې پبلک لایبلیټي دام کېدی شي، یعنې که چېرته یو څوک راولېږي د هغې سر خوږ شي او هغه د چا د غفلت د وجې نه یا د هغې د بزنس د وجې نه، نو هغه پبلک لایبلیټي د اپلای کولی شي. او همدا شانتې که د چا فرضاً نظر لاړ شي یا سترګې ړندې شي د بل نفر د غفلت د وجې نه، کېدی شي که لاس مات شوی، که خپه ماته شوي، هم کېدی شي که زنګونې، که ولی. نو پبلک لایبلیټي د ټولو نه ډېر ښه دی چې باید مونږ د هغې حفاظت باید مونږ وکړو. همدا وجه ده چې پبلک لایبلیټي په کوم ځایونو کې کېږي، لکه مخکې چې بیرې ویلې چې پبلک لایبلیټي سایکیټریک څوک چې تکلیف یعنې انزایټي ورته پیدا شي، ډېر مشکلاتونه ورته پیدا شي، خوب له نه ورځي، نو پبلک لایبلیټي ته اپلای کولی شي. او هر هغه څوک چې اوس د رواني تکلیف باندې اخته شوي، نو لکه بیرې چې مخکې ویل چې 6,440,000 ډالر اخیستي دي، چې دغه یعنې هغه ورقې چې دی هغې له ډکوي، دغه چې دی یعنې ډېر هغه اساسي مهمه مرحله ده چې باید هغې په دې ورقې باندې کله ډکېږي. کله چې وکیل ته ځي دا ورقې هر څوک نه شي ډکولی، دا خاص وکیلان لري، د پبلک لایبلیټي وکیلان دي چې باید هغې ته لاړ شي او ډکې کړي. همدا شانتې یو څو مثالونه بیرې ورکړل، مثالونه دا ورکړل چې فرضاً په شاپینګ سنټر کې ګرځو مونږ او هغلته فرضاً راولېږي یو کیلې پوستکی لیدلی، یو څه شی لیدلی، یو څوک چې راولېږي او هغه زخمي شي یا ډوکی مات شي، نو د دې قابل دی چې باید هغه پبلک لایبلیټي باید ورقې ډکې کړي. او همدا شان که څوک سپی وچیچي یا په پارک کې ځینې خلک دي چې په پارک کې سپي بغیر د رسۍ نه ګرځوي، نو هغې هم فرضاً کولی شي. او همدا شان ځینې ماشومان دي چې په فرضاً پلی ګراونډ کې لوبې کوي، نو که په پلی ګراونډ کې یعنې د کاونسل په مطابق نه او هغه صحیح جوړ شوي نه وي، نو پبلک لایبلیټي کولی شي. یا فرضاً په فوټپات باندې دا ده چې یو ډسیبل انسان روان دی او هغه فوټپات صحیح نه دی، نو که چېرته هغه زخمي شي او هغه زخم د هغې دایمي، نو هغه هم کولی شي. نو دا چې دی ډېر مهم دی. او بل دا دی چې په شاپینګ سنټرو کې دا دی چې ځینې شاپینګ سنټرو کې ځینې شیان خرڅېږي، هغه شیان چې فرضاً زمونږ د صحت دپاره ښه نه دي او هغې نه مونږ ته تکلیف ولاړېږي او مونږ اخیستې، فرضاً په مثال په توګه ځینې سامانونه د لوبو د ماشومانو دپاره که هغه ماشومان استعمال کړي هغې دپاره محفوظه نه دي، نو دغه هم پبلک لایبلیټي کې راتلی شي. نو پبلک لایبلیټي چې ده د ټولو نه ډېره مهمه ده، ځکه چې پبلک لایبلیټي هر څوک چې ورکوټی بزنس لري یا چې ټول لري، نو د دې د خاطره چې تاسو د سوپر مارکیټ او ټولو ځایونو ته چې بیرې چې مخکې ویلې چې ځو، او بعضې وخت کې زینې لکه حکومتي زینې جوړې شوي دي، په دې زینو کې ریک نشته چې زاړه خلک یا خلک ترې راښکته کړي، خو کله چې راښکته کېږي یا د هغې نه ولېږي یا یې لاس مات شي یا یې پښه ماته شي، نو پبلک لایبلیټي کولی شي. نو هر هغه څوک چې دغه مشکلات لري او تکلیف لري، نو د سلاید اینډ ګارډن سره د بیرې سره او د نورو وکیلانو سره ارتباط نیولی شي او ورته وتلی شي. نو ما دا ډېره مختصر راټول کړي او تاسو ته مې ټولو ته وویل، نو که څه مشکل لرئ تماس نیولی شي.
و در این قسمت از برنامه نوبت وکیل دیگر ما هستند که خانم لی هستند که ایشان هم در همراهی با آقای بری اطلاعاتی را به این برنامه اضافه خواهند کرد.
Okay, so by way of introduction to medical law, I thought it might be interesting to start by sharing some facts and figures in relation to the number of healthcare services in Victoria each year. Please keep in mind that these are pre-COVID-19 figures, so it may well have changed since then. So each year there are more than 55 million Medicare services, well over 1 million hospital admissions and thousands of avoidable adverse events. I've said in the slide that more than 50% of cases are against the public health system, and that's right, but I would actually say it's more like 70% of our cases would be against the public hospitals as opposed to private doctors. Next slide, please. In the medical law space, it is well established by the law that doctors and hospitals owe to their patients the duty of care, of reasonable care. So it's not perfect care, it's just reasonable care. So in order to bring a claim for medical negligence, it must be established that there was a breach of the duty of care owed to you by your healthcare provider. That is, that you receive medical treatment that is considered by way of expert evidence as negligent, and that negligent treatment has caused you to suffer an injury that was otherwise avoidable. And as Barry explained, an injury must be regarded as significant in order to claim damages for pain and suffering. The basic legal test in medical law is what we call the but-for test, and that is, but for the negligent medical treatment, would the injury have occurred? And if the injury would have occurred in any event, negligence will not be proven. And there's a famous case from the 1960s in England that is often used to explain this but-for test. And it was about a man named Mr. Barnett who fell very, very ill, and he went to hospital for treatment. And the doctor there declined to examine him or treat him and told him to go to his local GP the following day. However, it transpired that he had consumed a cup of tea that was contaminated with arsenic. And so, although the doctor may well have breached his duty of care by failing to physically examine his patient or to treat the patient, because there was no effective treatment for arsenic poisoning, Mr. Barnett was always going to suffer the same fate. Okay, next slide, please. Okay. So there are various aspects to the duty of care owed to patients by doctors and hospitals, and to demonstrate this, I thought I would talk you through some of my own cases, past and present, which highlight the categories of medical negligence claims that we most commonly see in our Dandenong office. First aspect is failure to treat adequately, or if at all. And so my client, he presented to a hospital, an emergency department, on multiple occasions. He had severe lower back pain. Because he happened to be a farmer, it was presumed by the doctors that he had back pain due to heavy lifting. So he was given painkillers at each presentation. He presented about 3 or 4 times over 2 weeks, and he was discharged home. He was told to arrange physiotherapy for his back. Now, it turned out that he actually had an infection developing at the base of his spine. And so an abscess had formed at the base of the spine. It had entered his spinal cord, and it rendered him a quadriplegic. So had the abscess been treated with antibiotics or had been drained at the various presentations to hospital, the infection would have resolved and it would not have infiltrated his spine, and he obviously then would not be a quadriplegic. And he was 25 years age at the time. And so his claim settled for well over $5 million, and as Barry explained in terms of compensation, that was made up of pain and suffering, loss of enjoyment of life, and the large portion of the compensation really is for the cost of the care that he requires for the rest of his life because of his injuries. The second aspect that we commonly see is failing to correctly diagnose a medical condition. And another emergency department case of mine that I'll never forget involved the misdiagnosis of a young 9-month-old baby. So she presented to hospital very, very sick with a fever, a virus, a viral illness of some description. She also had a terrible rash. Her parents were advised that the rash was viral in nature and nothing to worry about. The child was sent home, and during the night deteriorated and became unconscious. She was rushed back to the same hospital. She was admitted, and it turned out that she had meningococcal disease, and that meningococcal disease was caused by the severe sepsis, and as a result she had to have her leg and arm amputated. And had she been given antibiotics, she would have avoided the requirement for the amputation. And her case resolved for over $3 million as well. And we don't see the meningococcal cases anymore because there's now a vaccine for children, for young babies. Okay, failing to advise or appropriately warn a patient of material risks associated with a particular treatment. Now, there is a very famous case about this, which I'll talk you through shortly, but ultimately doctors must warn their patients of material risks associated with medical treatment. Now, this is a subjective test, which means that the doctor must warn a patient of even the most remote risk if that patient attaches particular significance to it. Now, not keeping up to date with current state of knowledge or developments in medicine is another area that we're seeing, unfortunately. And we mostly see this in orthopaedic injuries, where surgeons have used outdated surgical techniques to perform, for example, a knee replacement. And that then puts the patient at a higher risk of injury or complications occurring during the surgery. Failure to refer off to a specialist where appropriate is the other common case that we see, and that's typically GP presentations. And we see a lot of clients presenting to GPs with moles on their skin, and they're reassured that the moles look harmless, and they're not referred off to a dermatologist or a skin specialist for review, and then it turns out that mole is actually a melanoma or advanced cancer. And we also see in the cancer cases women who present with breast lumps, and GP does not refer for mammogram or ultrasound or biopsy, doesn't investigate the lump, and it turns out that the lump is a metastatic breast cancer and has spread to other organs. We also see technical surgical errors, and this is very common. And for example, a patient who requires intubation, we're hearing a lot about intubation with the COVID patients, and that's where they put a tube into the trachea, which allows you to breathe. So that gives oxygen to the lungs, pumps the oxygen to the brain. And this tube is, by error, inserted into the esophagus, which is where your food travels down into the stomach. And so oxygen is directed into the stomach, and therefore there is no oxygen going to your brain, and the patient dies or suffers a hypoxic brain injury. Next slide, please. Slide 5. Okay. Gary spoke to you about the common law, which is judge-made law, so I thought I would take you through some specific case law about doctors' duties. So this case is Dobler and Halverson, and the plaintiff, he attended upon his GP, complaining of having fainted on 3 separate occasions over a 2-week period. So the GP examined him and found that he had a heart murmur, so his heart was making an irregular beat. But he failed to follow this up or do anything about it. So 2 weeks later, the plaintiff, Mr. Halverson, suffered a cardiac arrest and ended up with a significant brain injury, brain damage. And the cardiac arrest was caused by the undiagnosed cardiac condition, which was called long QT syndrome. And so this case required consideration of whether the doctor ought to have undertaken further tests such as an ECG or cardiac investigations, or indeed referring the patient off to a cardiologist, and whether, if those investigations had been undertaken, the long QT syndrome would have been diagnosed and treated before the cardiac arrest. And the evidence was very clear that that would have been the case, that had he had the appropriate investigations, he would have commenced treatment by a cardiologist and would have avoided the cardiac arrest that has rendered him with significant brain damage. Next slide, please. The next case is Tai and Hatzistavru, and this involved a specialist gynaecologist, and his patient had attended upon him because she was suffering from very heavy vaginal bleeding after menopause, and so she was advised that she would require surgery to investigate the cause of the bleeding, and he referred her off to hospital with the relevant admission forms. And now, by some oversight, the hospital didn't book her in for the surgery, and the doctor didn't follow it up, and so there was a delay of about 6 to 12 months before she actually underwent the surgery. And when they opened her up, it was found that she had metastatic ovarian cancer. So she had ovarian cancer that had spread to other organs in her body, and she was on death's door. Now, the evidence was such that had she undergone the surgery when she had first seen the gynaecologist, they would have detected the cancer at that point of time, removed the ovaries, and there wouldn't have been the spread of the disease, and she would have survived. There was a cure. It's a very sad case. Next slide, please. Okay, it's another delay in diagnosis case, and similar to the melanoma example I gave you. This case, and unfortunately we have many cases involving the delay in diagnosis of cancer. In this case, it concerned a failure to diagnose melanoma on the sole of the plaintiff's foot. And the plaintiff had presented to his doctor, his GP, on many occasions with pain and discomfort in the foot. And his GP said, look, I think it's a wart, and used cryotherapy to freeze the wart off. The wart returned, or the lesion returned, and 18 months later, he was diagnosed with a very, very rare case as a metastatic melanoma, but a very rare type. And unfortunately, while the plaintiff was able to prove that the doctor was negligent in diagnosing the lesion as a molar melanoma rather than a wart, that was a negligent diagnosis, was a negligent conclusion to arrive at. The cancer was so aggressive, it was such that the die was cast for him. He was never going to survive this cancer, even with the best treatment and even with the most prompt diagnosis. So he lost the case. And that just highlights the complexity of medical law cases. They're extremely complex. And this case is King and Western Sydney Local Health Network. Next slide, slide 8. The next case, King, really highlights how complex medical negligence cases can be. And to Barry's point, you really need to see a lawyer who is a specialist in medical law claims because of the complexity. So this is another very sad case. And the plaintiff is a young child, and she was diagnosed with congenital varicella syndrome. Now, what happened was when her mother was pregnant with her, the mother contracted chickenpox. And so the plaintiff had an older sister, so she had a 2-year-old sister, and the child had chickenpox. And so mum had never had chickenpox before and was very worried about getting chickenpox while pregnant, because we know that viruses in pregnancy can cause deformities and fetal death. So she went straight to hospital and expressed her concern. And at the time, there was a vaccine available. So there's a vaccine that they could administer her. For patients who had never had chickenpox before, they could administer this vaccine, and she requested that, but they didn't give it to her. I'm not sure why they didn't, but they didn't. So of course she ended up mum contracted chickenpox, and the baby was born with this syndrome called congenital varicella syndrome, which is a direct result of the mother being infected with chickenpox. And she had very significant brain injury, brain damage. She had deformities, very seriously ill, profound disabilities. Now, the court found that the hospital was negligent in failing to administer the mother with this vaccine. They should have done that. But the medicine was such at the time in the literature that there was only a possibility, not a probability, because that the vaccine would have made a difference. Would have stopped her from getting the chickenpox, developing the chickenpox, which is unlike the COVID-19 vaccine, where we know you've got 90% chance of protection if you have the vaccine. But with this vaccine, it wasn't greater than 50%. And in medical negligence claim, we must prove on the balance of probabilities that your injury would be avoided with appropriate medical care, and this could not be proven in this case, and so this child lost the case. Next slide, please. Okay, so that's just more about this King case, the chickenpox case. So it's a sad case and demonstrates the complexity in medical law. Next slide, please. Okay, failure to warn. So moving on now to informed consent. Healthcare practitioners, so doctors, are required to warn you of the material risks associated with their treatment. Next slide, please. Okay, so when obtaining consent, the medical practitioner must warn, and I explained this a bit earlier, must warn of risks that you attach significance to. So, there have been cases in the past where, for example, a catwalk model had a mole on her face that needed removal, and there is a risk of scarring. Well, for her as a model, she needed to know about the risk, and she wasn't warned that there would be. She could end up with significant scarring. She's gone ahead, had the mole removed, ended up with scarring, was not warned about it. So it's a subjective test. It's what you, as the patient, attach significance to. And the famous case, if we go to the next slide, please, is Rogers and Whittaker. And in this case, Mrs. Whittaker had been blind in her right eye since she was a child. And Dr. Rogers, the eye surgeon, advised that he could operate on her right eye, so the eye that she could not see from, to remove scar tissue, and this would improve its appearance because her eye was kind of turning inward, and so she wanted to correct that. It may well also restore sight in that eye. Now she was, quite rightly concerned about damage occurring to her good eye, her left eye, during the course of the surgery, and she specifically asked Dr. Rogers the question whether anything could happen to her good eye. Could she lose sight in her good eye? Now, unfortunately, so she had the surgery, unfortunately no improvement to the right eye, to the eye that she could not see from, and she then developed a very rare inflammatory condition in her left eye, her good eye, which rendered her completely blind. And so the court, so this went to the High Court of Australia, and the High Court found that although the risk of damage to her good eye, which was assessed at 1 in 16,000, was considered minimal, a minimal risk that a doctor would not ordinarily need to inform a patient about, but because she, the plaintiff, had attached significance to the preservation of sight in her left eye, her good eye, that meant it was a material risk and she ought to have been warned about it. Next slide, please. Obstetric malpractice. Now, this unfortunately represents a very large portion of our caseload, and unfortunately both mother and child can be injured during the birth process, and these birth injuries can occur as a result of mistakes made by doctors and midwives. And I apologise in advance if there are any of you pregnant in this audience and this is particularly stressful for you to hear. So I apologise, and if you want me to skip through, I can. But I think it's important to know. So birth injuries, they can be wide-ranging, both in their nature and severity. And the most common birth injury that we see involving the mother will usually consist of third-degree vaginal tearing sustained during the delivery of the baby, and that will, often result in incontinence, both urinary and fecal incontinence. Then we see incompetent suturing, so when the doctor goes to repair the tear, it's not repaired, sutured appropriately, and injury occurs from that. Infections develop that aren't being appropriately treated. There's also, we see misdiagnosis of preeclampsia, which is a condition affecting women during pregnancy, and that can result in stroke and death if not picked up and treated appropriately. We have many cases involving the stillbirth of babies who have been deprived of oxygen during the delivery, or there has been a complication that has resulted in the death of the baby that was avoidable. We see a lot of injuries to babies from forceps deliveries, where forceps are used to extract the baby out. We see placental ruptures, so the placenta ruptures and splits open, and we see umbilical cord problems. We have cases in which a baby has been diagnosed with cerebral palsy, which is a neurological condition where the brain has been deprived of oxygen in a particular part of the brain, and these children require 24-hour, around-the-clock, lifelong care, and these cases attract many, many millions of dollars. And, the case in point here is the Bakhtar Hospital cluster of baby deaths. And you may recall this in the media in around 2013 and 2014. We acted for many families from Bakhtar who had delivered a stillborn baby, so their baby died during delivery, or their baby suffered a brain injury during the course of the delivery. And this is extremely tragic, and it became apparent in around 2014 that a significant number of baby deaths were occurring at a particular maternity hospital, Bakhtar Hospital, and so investigation was underway, and it revealed that there were many avoidable baby deaths, and there was a large-scale investigation. There were over 100 cases investigated by the relevant authorities, and there were 13 doctors, over 200 nursing and midwifery staff who ended up losing their jobs and have been deregistered. And Sloan Gordon acted for over 20 families involved. It was very sad. Okay, next slide. Actually, Basir, I think we can skip to slide 18 because Barry has covered all of the content in my next few slides, which relate to significant injury and compensation and the types of damages that can be claimed. Barry's covered that in detail, so I don't need to cover that today. So slide 18. So why people approach lawyers. So in my experience, my clients have never been explained to by their doctor why a bad outcome has occurred. They don't understand why they've gone in for surgery for a knee replacement and they've come out with their leg amputated. They just don't know the answer to that. And so they're coming to me because they want me to investigate the claim and find out those answers to why this outcome has occurred. Obviously, people want to bring a claim to bring about change in the hospital system, and that does happen with medical negligence claims. Often guidelines in the hospital system are rewritten based on our cases because, the hospital wants to make sure that this doesn't happen again, and so they will change their policies and guidelines, and that is really important to a lot of my clients because they want to make sure this doesn't happen to another family. Obviously, compensation is extremely important. Barry explained compensation and damages to you earlier, but obviously, in the context of children with cerebral palsy, they need around-the-clock care. They need carers overnight, and that is a huge burden on family. And so, by bringing a claim, you're compensated so that you can have the child with cerebral palsy can have all the care that they need into the future. And after the parents are gone, who is going to be looking after the child? And so the compensation really secures the future for the injured child and makes life as comfortable as it possibly can be. Moving on to the next slide. In medical negligence claims, 95% of cases resolve at mediation, so very few go to trial. And in my 15 years of being a lawyer, medical negligence lawyer, I've had 3 cases go to trial, which is much less than Barry and much less than I would like. But that's the nature of medical law, and that's because in medicine you can never say never. So there's always, it is subjective because the evidence to bring a medical negligence claim is based on expert evidence, and expert evidence can be subjective because you can never say never in medicine, and doctors form different views all the time. And that's why we have so many cases, because what one doctor thinks is appropriate treatment is not what another doctor thinks. Okay, next slide, please. Apologies is really interesting because a lot of my clients have said that if they had been given an apology by their doctor, or they'd received an appropriate explanation about why an adverse event has eventuated, they wouldn't have come to see me at Slater & Gordon. They would have accepted that and they would have gone on to move on with their life. But it's very rare that I meet a client who has been apologised to by their doctor or healthcare provider when an injury or catastrophe occurs. And and I don't understand why, because the legislation is very clear that An apology is not an admission of guilt. So if a doctor apologises, that's not going to mean that the doctor is admitting that they were negligent. So it is a shame that we don't see more apologies, and we're hoping that there will be a shift towards that in the future. Next slide, please. We also represent families at coronial inquests in circumstances where it appears that the death occurred as a result of medical negligence, and the role of the coroner is to investigate the cause of the death, but it's to make recommendations to hospitals by introducing guidelines, for example, to ensure that an adverse event resulting in death does not occur again in the future. And we certainly assist families with that process from the outset in drafting submissions to the coroner, but also representing the family at the inquest. Okay, next slide, please. Oh, and we're at questions. So thank you very much.
Thank you, Lee. Now we'll move over to Shamim. Shamim, if you can just unmute.
Thank you very much, Miss Lee. و در ادامه سخنان ایشان خانم شمیم اکبر هم به زبان پشتو برای ما ترجمه خواهند داشت.
ډېر ښه معلومات ورکړو دا چې د ډېره ښه ایکسپرټ او سلایډن ګورډن د میډیکل نیګلیجنس په باره کې. میډیکل نیګلیجنس څه ته وایي؟ د طبابت غفلت ته. هر هغه څوک چې د طبابت د غفلت د وجې نه زخمي شي یا مریض شي نو هغه یو اندازه کمپنسیشن یا معاوضې حقداره دی. کله چې څوک ډاکټر یا نرس غفلت وکړي نو خپله په میډیکل کې دا قانون دی چې هغې ته باید یوه اندازه پیسې ورکړل شي، ځکه چې دا د ډاکټر او د نرس او د میډیکل د وجې نه دغه باندې دا تکلیف راغلی دی. نو شفاخانه یا ډاکټران په خپله همدغه د دې قانون چې غفلت د وجې نه شوی دی کومک ورسره کوي، او هغه ډاکټر چې فرضاً خپل پروفیشنل یا مسلک یې سم سرته نه دی رسولی نو دا مجبور دی چې د دې کومک ورسره وکړي. اول دا دی که ډاکټر چېرته یو څوک یو چا ډاکټر ته ورشي، ډاکټر باید اول معلومات وکړي، معاینه وکړي او بیا باید تشخیص ورته وکړي. تشخیص ورته وکړي دا د ډاکټر وظیفه ده. د ډاکټر وظیفه دا نه ده چې فرضاً هلته څوک ورشي صحیح معلومات ورنه کړي، تشخیص یې ونه کړي او ورته ونه وایي چې یعنې څه تکلیف لري. کله چې په طور مثال مخکې چې لی ویلې ما ځکه دا سمرایز ته مهم ټکي مې ترې راواخیستل، لکه مخکې چې لی ویلې چې یو څوک ډاکټر ته تللی او ورته یې ویلي چې زه چې دی زما ساه بنده کېږي او تکلیف لرم، د 2 ځله ورته تللی خو هغې پرې دغه غور نه و کړی، نو هغې باندې 2 هفتې بعد نه ای سی جي ته معرفي کړی او نه سپیشلیست ته د زړه معرفي کړی، نو هغې باندې کارډیک ارست راغی. کله چې کارډیک ارست راغی نو هغه د میډیکل نیګلیجنس و، نو هغه مجبور و چې هغه فرضاً دې ته اقدام وکړي او یوه اندازه معاوضه واخلي. نو دلته هر څوک چې فرضاً د کینسر یا فرضاً هر تکلیف چې لري باید مخکې نه ورته ووایي، معلومات ورته ورکړي او هر هغه تکلیف چې دی لري د هغې خطر هم ورته ووایي، یعنې د دې خطر د دې تکلیف وروسته دا خطر هم شته دی باید ورته ووایي. همداشانې څوک چې فرضاً د ماشوم کېدو په وخت کې د میډوایف یا د ډاکټرانو نه ډېر نیګلیجنس یا غفلت کېږي نو هماغه دی چې زیات ماشومان معذوره او ډسیبله پیدا کېږي. نو کله چې پیدا شي لکه چې مخکې چې لی ویلي چې یو ماشوم هغه شوی او هغې ته دې تکلیف پیدا شوی یعنې هغه ماشوم وشو خو دا دی چې تکلیف یې تر عمره پورې هغې سره دی. نو همدغه وجه ده چې باید همیشه باید موږ د دې شیانو نه استفاده وکړو. وکیلان چې دي دلته خپل مسلکي وکیلان دي د میډیکل نیګلیجنس چې هغه سلایډن ګورډن سره کار کوي او لی لکه مخکې چې وویل چې زه 15 کاله کېږي چې زه د سلایډن ګورډن سره کار کوم د میډیکل نیګلیجنس په باره کې. نو دا دی چې ځینې خلکو ته وایي خطونه راشي که یو غلطي چې چا نه ډاکټر یا د نرس نه وشي نو هغې خپل معذرت دې وغواړي، ساري دې وکړي، اپولوجي وکړي، نو دا بیا خلک هماغې نه خپل ژوند مخې ته وړي. اما دونه معلومات دی سره هغې سره نور نشته چې فرضاً مخې ته لاړ شي یا وکیل ته لاړ شي چې د خپل ځان یا د خپل صحت تپوس وکړي. نو همدغه وجه ده چې باید دوی ټول چې دي هر څوک چې فرضاً میډیکل نیګلیجنس یا د صحت په باره کې یا د طبابت په باره کې د ډاکټر یې که نرس یې که شفاخانه یې د هر چا نه غفلت کېږي باید هغه وکیلانو ته لاړ شي، خپل سپیشل وکیلانو ته لاړ شي. همدغه لی چې ده په ډانډینون کې سلایډن ګورډن سره کار کوي هغې ته باید ورشي او مخکې چې لکه بیري چې وایي هغه پبلک لایبیلیټي لپاره کار کوي نو هغه باید ورشي او هغې سره خپل کارونه مخې ته یوسي. نو دغه ما سمرایز کړی او ډېر ته مې ویلې نو بس ډېره مهرباني.
تشکر بسیار فراوان از اینکه همراه ما بودید و تا این لحظه از برنامه ما را همراهی نمودید. باز هم منتظر برنامه‌های ما باشید. با سپاس و قدردانی از شما عزیزان، شما را به خدای بزرگ می‌سپارم. خدا نگهدار.